I'm Daniel McCracken, Head of Private Client at MKB. I'm joined with Chris Quinn, who works with me in the Private Client team. It's not often, Chris, that we get to say that Intestacy is in the headlines across the world at the moment, but
no,
it certainly has been.
Very slow news week when Intestacy makes the headlines, but nonetheless a very interesting area of private client work and law.
For listeners, we're talking about Liam Payne, who sadly passed away a number of months ago. It's recently been revealed that he died intestate, which means that he died without a will, and recently found out that his estate was valued at in and around £24 million. So really, what does that mean, Chris, in terms of intestacy? What is that actually, the average person listening to this, what does that actually entail?
Well, it might actually also surprise you to learn that he is not the only celebrity to have died intestate without a will. I've been able to find out that there are 5 well-known celebrities who have died in the last number of years without a will, with Prince, Amy Winehouse and the actor Chadwick Boseman. So we add Liam Payne to the list. He died without a will, so therefore his estate and how it would be administered will fall to the statutory provisions within the rules of intestacy, which identify to us who exactly will benefit from someone's estate on a statutory footing, and the deceased, having not made a will, cannot decide and cannot dictate how their estate is to be administered.
So essentially it's what the statute says your will is if you don't have a will.
In any other words, yes, that's essentially it. And it really doesn't bring in anyone's actual intentions or what someone wants. We've lots of clients that come in to make wills with us, and they take quite a while to come to the decisions they want to make. Some can take months to decide on the individual bequeathments they want to make. Intestacy, none of that. It doesn't take into account inter-family dynamics. It doesn't take into account perhaps your charitable wishes. It doesn't take into account any of these things. It very clearly lays out who inherits an estate when there is no will.
Yeah, and I think it always surprises clients when you explain to them in an intestacy situation, because you still see them, becoming less and less frequent, but you do still see them irregularly enough. And it's always a bit of a surprise to a client that it's so inflexible. There's no,
sure.
If you're living together for X period of time that you're taking into account, or if you have kids together, you're taking into account, or whatever. It is a set regime. There is no moving away from it. And it sets out very clearly who is to get what. And it's only spouses, civil partners, and blood relations. And I think that's something that people really find surprising when you could be living with someone for some instances. People just, maybe don't believe in marriage, or they never get around to it, or
sure.
And they end up in a position where they think, well, everything that we have, we do together anyway. And so everyone knows that we're together. So we come up with this, you hear it quite often, this common law spouse myth that comes up. And I've had instances before where I've had to explain to someone that, you don't have an entitlement. It is only spouses, civil partners, and children initially. And beyond that, it's other blood relatives, parents, siblings, aunts, uncles, nieces,
sure.
nephews. And people get surprised that that's how it works. When they maybe have centered their lives around a particular relationship, or even I've seen examples as well of blended family dynamic coming in too, where
sure.
you have people that have had a relationship previously, had children previously, subsequently remarry. They don't have a will in place. That new spouse is going to be the first one getting first bite of the cherry,
yep.
The first one that's going to benefit from the estate, and potentially leave nothing to the first set of children from that first relationship. And that's a very difficult situation for people to understand and accept, because they just think, well, surely there's a way around this. Surely there's something to take into account the complexities of the relationships and the dynamics. Intestacy is entirely a blunt instrument. There's no flexibility built in. And when you're dealing with any sort of wealth, particularly when you're looking at 24 million of wealth, it's a pretty daunting prospect to have such a rigid set of rules in place.
Yes, and well, the cure to that and the flexible instrument to be used is a will, especially in these we live in a complex world. Perhaps 50, 60, 70 years ago, life seemed to a lot of people a lot more straightforward, quite black and white. We live in a very dynamic time, and you're absolutely right. Families, relationships change over time, and I think particularly in those instances, we can't leave it to intestacy. And certainly a will has to be considered and has to be, you have to engage the right professional. Quite often in those kind of situations, especially perhaps in a second marriage, you may have made a will previously and you think, well, that does me. But once a matrimonial agreement has been set into, once a decree absolute has been issued, and certainly when you're remarried, it sets aside any previous will you may have entered into. So it's very, very important that people, as they progress through life, when there's changes in terms of your circumstances, if you have a business, property, the right mechanisms need to be put in place. Yes, there's a statutory safety net there, for want of a better word, in intestacy. But as we can see with Liam Payne's situation, £24 million, we know this now because his family, his personal representatives will have extracted letters of administration which make those figures and the value of his estate now public knowledge. So we can now speak to Mr. Payne's estate, and ultimately all of that on the rules of intestacy under that safety net. He died without a will. All of that estate has been left to his son, who is a young child, and will ultimately be held on trust until he's 18. And Daniel, you're the trusts expert here. In what way is that trust held?
Well, that's what's quite again where you end up in a situation with the rules of intestacy are entirely blunt instrument. Quite often when you're planning and you're looking at a will with someone, modern day mindset is generally that an 18-year-old is unlikely to be responsible enough to receive a large sum of capital, particularly a £24 million large sum of capital. And quite often parents think, oh, I want to protect them from everything that, an 18-year-old might be going through in life now, where they maybe might get an early relationship where things might not work out the way that they might hope, or they have friends that just want to go out partying or do whatever with the money, and they end up using it in ways that they maybe shouldn't or maybe wouldn't be prudent to use them. So quite often when you're planning, parents are thinking, well, I don't want them to get it at 18. I want them to get it at 21, or I want them to get it at 25. And actually, the current tax regime when it comes to trusts is actually built in to allow that to happen. There are some benefits. It's not wholly beneficial to do it. There is some trade-off, but largely if you're leaving assets and you're a parent, you're leaving assets in your will and you want to hold it over so that they can't get the capital until they're 21 or they're 25, there are some tax benefits to doing that. So even the tax system recognises this desire for parents to protect their children from receiving too much inheritance too soon. The rules of intestacy have no such nuance. So Bear in this situation will receive £24 million at 18, unless there is an application made to the court to set that provision aside and allow it to be held for longer. And that is a power that the court will exercise pretty reluctantly. You need to give very good reasons for it. And at 24 million, there may be some scope for something like that to take place. But the default position will always be that an 18-year-old will receive the lump sum capital at 18, and it will only be held on essentially what's called the Bear Trust.
Pun intended, of course. And there are options. You're speaking to that. There are options in an intestacy to perhaps vary the estate, but that's a very much an uphill struggle and within the gift of the court to adjudicate on through perhaps a deed of variation. Again, Liam Payne's estate being been a well-known individual and of such a high value, perhaps an argument could be made, but there are options there for variations, although albeit it's not an ideal situation.
Absolutely. And as we said earlier, you know, we're focusing very much on there being a child here, but there's a partner involved as well. I don't know the ins and outs of Liam Payne's situation. As we said earlier, in intestacy, your partner gets nothing unless you're married or in a civil partnership, unless it's a formal relationship. So you end up in a situation where you've got £24 million going to a child, and say him and Liam Payne and his partner did have a long-term relationship and, you know, lived their lives together, that partner gets nothing.
No.
Everything is going directly to Bear. Now, there are, when we say about options and what you can do in terms of trying to deal with a situation like that, there's the likes of a deed of variation where everyone's 18 and over and they're get properly advised and they're entering into an agreement where they vary the law to say, I don't want it to go this way, I want it to go that way instead. And it's usually a tax neutral thing. That will not exist for someone who's under 18, and you would need to make special provisions through the court for that. And if they are all over 18, basically relying on their good graces to give effect to that. So if you're not one of the ones benefiting under the rules, you won't get an automatic entitlement to anything. So it gives rise to disputes, basically. And we do see this. There's a couple of different types of disputes that come up out of these situations. The first being that you look at potential for constructive trust. It's a very legal term that basically means that a property might be held by one person in their sole name, but in reality it's held for the two parties, the two members of that relationship. So your classical situation is husband and wife are buying the first property. The husband, it's all in his name. The wife doesn't work. She gives up the opportunity to work, and she then raises the kids, and she's the homemaker, etc., etc. That's the stereotypical scenario that usually comes up. And in that scenario, actually, whilst the law might say, the deeds might say, he owns the house, in reality, they own it together. So you look at whether or not there's potential for that constructive trust for the likes of a partner as a starting point, because that's an actual interest in something. It's a proprietary interest, and it's an entitlement to something, albeit still adjudicated by the court. An alternative position of where there isn't that kind of interest is an inheritance claim. We do see this where, you know, generally speaking, if you're making a will, you're sound mind and you are free of any influence, you can do whatever you want with your will, and you don't really have to justify it too much. You might have to justify it to me taking your instructions because I want to know and I want to evidence everything that you're saying, but you don't have to justify it to anyone else. That position has a kind of check and balance on it with an inheritance claim under the inheritance order, which basically says, here's a list of people that you should give reasonable provision to, and if you haven't, they have the right to bring a claim. That doesn't mean that they get anything outright. They don't have an entitlement, but they have a right to bring a claim and have the court assess whether they are due something from the estate, reasonable financial provision from the estate. And that can apply to an intestacy as well. So you could end up in a situation with, if you have a £24 million estate and there is a partner, one of the classes of people that can bring a claim is someone that is cohabiting with the person that's died for a period of 2 years or more, continuous period of 2 years or more, as if they were husband and wife or as if they were civil partners, even though they haven't formalised their relationship. And in that scenario, that person can bring a claim. Or if someone was dependent financially, wholly or partly, on the person that's died, they can also bring a claim. But you're then in the sphere of litigation and trying to bring a claim through court, which may be resisted by the estate. And if it's resisted by the estate, then you're running lots of risk by taking a claim in court. This could all be avoided by making a will and setting out very clearly what you want to happen and addressing with your advisor, who should you maybe leave something to? Where are there potential claims? And if there are potential claims, how can you try and mitigate them with your planning by looking at the overall picture rather than just ignoring it all and signing something that
I'm
hoping for the best, essentially.
Yeah, and then trying in a litigation situation to try and ascertain perhaps intentionality behind someone who is no longer there, to be able to speak for themselves.
Exactly.
That is the difficulty, and it brings us, of course, to what can be done then to mitigate all of these things, and the first being engage a solicitor and make a will.
Exactly, and you don't need to have 24 million to make a will.
No.
I suppose we should say as well that the bit about intestacy, that if you don't have assets, your intestacy position may be fine for you. Maybe you're happy enough that first £250,000 goes to your spouse or civil partner, and the rest is shared between your spouse, civil partner, or your children. That may be fine by you, but what happens if you and your partner have both passed away, and what do you want to happen to it then? Or who do you want to actually look after everything? And particularly if you're a parent, who do you want to appoint as a guardian for your children if your children are under 18 at the time that you pass away, and either you pass away and you're the sole parent that's looking after the children, the sole resident parent, or the other parent has also died? Who do you want to look after the kids? That's something you can do in your will. So you don't necessarily have to have heaps and heaps of money to be thinking about making a will. You should make a will if you have property, but you should also probably make a will if you have children.
And whilst not getting bogged down too much into the different details of the estate of Liam Payne, but I know a lot of clients that come in to see me when I ask them about the appointment of an executor or a trustee for their will. That's not a quick decision. That actually takes time for a lot of people to really consider who would they like to administer their estate, who do they trust and would want to give authority to someone to see to it that their assets are administered and dealt with, and if there's a trust, that the trustee acts in the best and most beneficial way for any beneficiaries. And in an intestacy situation, you don't get that choice. It's a very strict passing off, and it may end up being a person that you would not have wanted to be the person charged with administering your estate. So it's not just as simple as, well, I'll just leave it all. Will let anyone that survives me deal with. You enter into a lot of different situations that you would have no control over, and perhaps the reality of knowing that you can leave everything you have, and that there's someone there as an executor or a trustee that will deal with, as you had mentioned earlier, those blended families.
Well, exactly. That and the blended family thing. Quite often what you see is that everything's all fine until then one of the parents or the parties to the marriage pass away, and then all of a sudden you see the difference between siblings and step-siblings. And it's quite jarring seeing that happen. So it's really important that if you have assets, or you have children, or you have complex family situations, that you engage with a professional to look at your situation as fulsomely as possible, so that you can mitigate as a lot of the different things that we're talking about here, because the position without a will is not fit for purpose quite often.
No.
It's only meant to be there for the last case scenario, and also as a very rudimentary thing that deals with simple family circumstances. Okay, well, thanks everyone for listening. Thanks, Chris, for your time this afternoon.
And thank you, Daniel. We're here for all private client needs, and we can be contacted via the website, by LinkedIn, or just lift the phone.